And that is going to be key, because the defense highlighted some arguably significant holes in the prosecution's case against singer David for the alleged murder of 14-year-old Celeste Rivas Hernandez. So what we want to do is talk about what those gaps may be and what the prosecution may do. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber.
On April 23, 2025, a 14-year-old girl named Celeste Rivas Hernandez allegedly arrived at a home in the Hollywood Hills and then, by all accounts, simply vanished from every digital record she had ever left behind. First, the only person who could have placed her at that residence that night, the Uber driver, could not definitively confirm he dropped her off there. Second, the medical examiner, under cross-examination, admitted he could not rule out that the two penetrating wounds identified as the cause of death occurred by Celeste's own hand. Third, the one piece of physical evidence most likely to connect dismemberment to the defendant, a Makita brand chainsaw ordered to his home days after her death was reported, has never been recovered. These are not theories. These are documented gaps that emerged from the preliminary hearing record itself. And in a case already flooded with headlines and assumptions, this video is about separating what is actually on the record from what has been allowed to fill the silence around it. Let's start with what is established and what is not around the night of April 23, 2025. Prosecutors allege that David Anthony Burke, the recording artist known as D4vd, arranged for Celeste to come to his residence on Dini Place that evening. Text messages presented at the preliminary hearing reportedly showed an exchange about an address, an Uber arrival, and an unlocked gate. Detective Corey Farrell testified to this documented exchange, but here is where the record becomes genuinely complicated. The Uber driver, according to Detective Farrell's own testimony, could not definitively state that he dropped Celeste off at that specific home. No surveillance footage of Celeste or Burke at the residence that night was presented. No witness was called who saw Celeste enter the property. And no witness was called who testified to observing anything during the approximate 20-minute window in which prosecutors allege she was killed. That 20-minute window itself is constructed from circumstantial inference. Prosecutors derive it by mapping the last activity on Celeste's phone to the first outgoing texts from Burke's phone, texts that prosecutors frame as a manufactured alibi, asking where she was. That is a coherent prosecutorial theory. It is also, by definition, an inference, not a witnessed event, not recorded footage. An inference built from digital breadcrumbs.
I want to do something here. I want to do something very, very specific when it comes to David Anthony Burke, the singer facing first-degree murder, continuous sexual abuse of a minor, and unlawful mutilation of human remains charges in connection with the death of 14-year-old Celeste Rivas Hernandez. By the way, I just got to say this real quick. You know, we've been covering this case, but if you're interested in looking at the documents and getting a full 360-degree perspective on this, everything we have, go to the Law and Crime Plus app, because we have a case file section for all of the big cases that we follow. We got one for David, so check it out. A lot of information there that we touch upon a lot here on Sidebar, but if you want to read everything and see it for yourself, it's up there. I want to look at the potential holes in the prosecution's case, the potential gap.
And in a first-degree murder case carrying special circumstances allegations that could result in the death penalty, inference alone will face intense scrutiny from the defense at trial.
And the reason we're doing this is because we just went through the preliminary hearing. And this gave us a glimpse at some things. And even though, yes, the judge ruled there was sufficient evidence, there was enough evidence for this case to move forward, we know that the prosecution doesn't have to present everything they have at a preliminary hearing. And by the way, DA Nathan Hochman said what was presented by our office over the course of the last week is a small but illustrative fraction of the evidence investigators have accumulated that proves defendant Burke is guilty beyond a reasonable doubt of the brutal murder of Celeste Rivas Hernandez. And B, the bar is so low at a preliminary hearing, right? You just have to show sufficient cause to hold someone.
This is worth sitting with because much of the public conversation around this case has already assigned guilt with a confidence the documented record does not yet support. Now let's move to the forensic evidence and to a moment in the preliminary hearing received far less attention than it deserved. During cross-examination of Deputy Medical Examiner Dr. Grant Ho, defense attorney Marilyn Barksky established several factual concessions on the record. Doc. Ho confirmed that advanced decomposition, which is present in this case, can affect the accuracy of toxicology results. He confirmed that not speaking with Celeste's relatives about her mental health history prior to completing his autopsy report was noted. He confirmed that he could not rule out that the two penetrating wounds identified as the cause of death occurred within seconds of each other by Celeste's own hand. And when asked directly, quote, "Is it fair to say that you don't know the circumstances under which these wounds occurred?" Dr. Ho replied, quote, "Correct." Now, the defense appeared to use this line of questioning to lay groundwork for a theory that Celeste may have harmed herself. That remains a contested and unproven claim. But what is documented is that the medical examiner, under oath, acknowledged meaningful limits in what the autopsy could definitively establish.
Assuming she goes into the house, what happened? How do you know it was first-degree murder with special circumstances? Neither Detective Farrell nor the deputy medical examiner could precisely say what happened. And that is complicated by the fact that no murder weapon was ever recovered. And to give you an idea of what I mean, you go to the cross-examination of Dr. Grant Ho, this deputy medical examiner that I mentioned. This is when the defense was questioning him, because the defense asked if advanced decomposition, which we have in this case, can affect the accuracy of drug results in toxicology testing. The witness says potentially. The defense asked if it's helpful to know whether a person has a mental health history, whether they're suicidal, whether they're a habitual drug user while preparing an autopsy report. The witness says potentially. Dr. Ho didn't apparently speak with relatives about these characteristics or potential characteristics. And the defense, as far as we could see, seemed to insinuate on cross-examination, is it possible that Celeste may have stabbed herself, that she may have done something to herself? You know, defense attorney Marilyn Benarski had Dr. Ho establish that he cannot rule out that the two penetrating wounds, which he claimed were the cause of death, occurred within seconds of each other. Quote, "You cannot determine whether Miss Hernandez was holding the knife that caused the two wounds, correct?" Correct. You can't rule that out, right? So that is a consideration, but we would expect to find hesitation marks. And then he was asked, is it fair to say that you don't know the circumstances under which these wounds occurred? And he replied, correct. Assuming, of course, it's a knife, right? We don't have the murder weapon. That leaves room for reasonable doubt.
There is also no murder weapon in evidence. No knife, no blade, nothing recovered that has been forensically tied to the two wounds described as the cause of death. Myths often move faster than medical examiner concessions. And in this case, the public narrative had largely settled on a version of events before those concessions were ever made in open court.
The defense trying to explore or exploit. That's what I want to get into. Now, let me be very clear about something. Yes, David Anthony Burke, David, he is innocent unless proven guilty. And even before I go into all the potential holes, the prosecution has already presented some arguably compelling evidence at this preliminary hearing. I mean, when it comes to the continuous sexual abuse charge, in my legal opinion, the prosecution has a lot. If they're trying to prove that David had an illegal sexual relationship with a minor over a period of time, when LAPD detective Corey Farrell was on the stand, he went through all of these alleged sexually explicit photos reportedly on David's phone. I'm not even going to get too specific on this, but basically, it was alleged these were images of the singer engaging in sex acts with Celeste. Naked photos, text messages about Plan B, pregnancy, an abortion, sexual positions, the relationship, emergency contraception.
This brings us to what may be the single most underreported detail in this entire case, the chainsaws. Prosecutors allege that Burke ordered 3 chainsaws to his home in the days following Celeste's reported death. 2 chainsaws were recovered from the garage at the Dini Place residence. Both were tested for blood and DNA. Both returned negative results. A criminalist testified that if those blades had been used for human dismemberment, cleaning them to a point where they would produce a negative result would not have been possible. That testimony cuts in both directions. It may suggest those chainsaws were not the ones used. But it also means that if dismemberment occurred as alleged, something else was used. The third chainsaw, a Makita brand 10-inch model reportedly delivered by Postmates, was not at the residence when investigators arrived. Prosecutors presented product photos of it. They do not, as far as the preliminary hearing record reflects, currently have the physical item. Deputy Medical Examiner Ho testified that certain dismemberment injuries in this case are potentially consistent with chainsaw cuts. But without the tool, connecting physical evidence to a specific instrument becomes significantly more complex. This is a documented gap, not a defense attorney's spin. A documented gap that the prosecution will need to address before a jury.
Of an alleged murder weapon. What exactly did David allegedly use to dismember Celeste? Because prosecutors allege that David ordered 3 chainsaws to this home, but the 2 that were found in the garage in this residence didn't test positive for blood or DNA. Same for an electric saw that was found. There was testimony suggesting that a criminalist posited that if the blades had been used for human dismemberment, they wouldn't have been able to be cleaned to a point where their testing would have resulted in a negative result. And what I'll note about that is the deputy ME, Dr. Ho, testified that certain dismemberment is potentially consistent with chainsaw cuts. So what's the disconnect here? Well, one of the things prosecutors talked about was this third missing chainsaw. And they presented product photos of this Makita brand 10-inch chainsaw, apparently from Home Depot, apparently delivered by Postmates. But detectives confirmed that the chainsaw wasn't at the place. As far as we can tell, they don't have it. I mean, is this the one? Is this the one that he allegedly used to dismember Celeste?
Here is a genuine question the record does not resolve, and one worth considering. If the third chainsaw was disposed of during the multiple trips Burke's Tesla allegedly made to Santa Barbara County in the weeks following, and the passport card belonging to Celeste was reportedly recovered in Santa Barbara County, what exactly is the documented connection between those trips and any specific disposal activity? The trips are corroborated by digital data. What was done during them remains, as of the preliminary hearing record, largely inferential.
Because if you don't have the tool, that's a gap. Now, I asked private investigator Steve Fisher about this after the preliminary hearing. He was actually in that preliminary hearing for a bit of it. He had been following the case from the very beginning. Here's what he said about the chainsaw.
Well, the medical examiner said, because of the state of decomp, they can't say for certain exactly like how long of a blade or sharp instrument that was or whatnot. And listen, I think everybody assumes it was probably a knife, but there was a lot of time that passed in between. So it's mind-boggling to me that there was any evidence such as pool or anything still in that garage. I mean, the stupidity, right? If you're trying to cover this up. And part of me wonders, if he just knew he was going to get caught and was just kind of waiting. Because this was
Do you think the missing chainsaw is the key?
Yeah, I think that chainsaw might be in Santa Barbara.
Really?
I think on the second or third trip, I think he could have been, getting, because if you look at that second trip, they're contending that it happened around May 5th, around Cinco de Mayo. And May 8th, I think he took another trip up there. And that makes me wonder if it was to dispose of things near that lake or something. But I don't know that for sure. I just think that could be a reason that the ID was ultimately found up there as well. It's like a disposal spot. But why he picked that, how he knew about that place is really mind boggling. Because I've been there. It's remote. It's just a road that really goes through that area. The roads that go off of it, there's some that go to a Boy Scout camp and stuff like that. But they're not well-traveled roads. So I don't know how he even knew about this place.
What is your read on how much weight a jury will give to circumstantial travel data alone? That's a genuine interpretive gap here, and one that will likely define a significant portion of the trial. Let's talk about the text messages, because they are more complicated than most coverage acknowledges. Prosecutors have emphasized messages that, in their framing, establish motive. Celeste allegedly sent messages threatening to leak damaging information about Burke, to tell her father, to end his career, and in one message from August 2024, reportedly referenced, quote, losing a pregnancy.
After she sends him this text, cut this S out, I'm seeing you today. Now, Blair Burke, David's attorney, reads this allegedly threatening text from Celeste that was dated April 22nd, allegedly telling David that she will end his career and tell her father, quote, so many lies about him, that she's going to mutilate his quote, I will tell my dad so many bleeping lies about you, dead ass. I will end your career and your life. I will damage anything. She allegedly sent this on April 22nd. Now, Burke apparently also read a text from Celeste explicitly threatening to make anonymous accusations and, quote, leak all that S I got on you. And this is apparently in reference to whether or not David was going to post on Asia Collins' social media accounts showing the two of them together. There seemed to be an insinuation that she was jealous of this person. Asia Collins is somebody who we've talked about before, apparently in David's orbit. And Celeste apparently told David she has his contact information, his mother's number, threatening to release all this information. And then you have texts like this where Celeste allegedly wrote to David in August of 2024, "I care about you. I killed my kid for you. I don't like talking about it because it gets me really upset, but I do anything to have it back." So why does this matter? Why is this all important? Well, here's the point. Yes, the prosecution can point to messages like that to say, yeah, she was threatening to expose him and ruin his career. He had a motive to kill her. So to protect his career, he lured her over and he killed her. After all, the prosecutors say his debut album, Withered, that was part of a $19 million deal with Interscope Records, that was set to release just a few days later on April 25th. So it goes to the special circumstances allegations, a part of the murder charge, right? That would lead to more severe penalties, possibly the death penalty, killing for financial gain, killing a witness, lying in wait, special circumstances.
The prosecution argues these messages show Burke had reasons to silence her, particularly with his debut album, Withered, part of a reported $19 million deal with Interscope Records, set to release on April 25th, just 2 days after her alleged death. But the defense has flagged a different reading of that same message chain. Text exchanges from April 22nd and 23rd, presented during cross-examination of Detective Farrell, reportedly show Celeste demanding to see Burke before he traveled abroad, and Burke initially declining. The defense argues this undermines the prosecution's narrative that Burke lured her to the property with predatory intent.
It was reported that the defense attorney asked Detective Farrell if Celeste had a history of domestic violence, whether there were messages referencing alleged mental health issues about Celeste. And while the judge wouldn't permit the presentation of that evidence at this stage of the proceedings, it is possible that could come out at a trial. But you couple that with the text messages or the apparent text messages from April 22nd to the 23rd, 2025. Again, this is the time period that we're talking about, the key moment when Celeste was allegedly killed. These were highlighted by the defense on cross-examination of Farrell. They arguably show that Celeste was demanding to see David before he traveled abroad, that she begged to see him in person, that he tells her no. This would defeat the narrative that he allegedly lured her to the property to kill her. And
if Celeste was the one pushing to come over, if Burke agreed to the meeting rather than orchestrating it, the lying in wait special circumstance allegation becomes significantly harder to prove.
Circumstances, right? But the defense could also argue that she was the one who initiated this, that she begged to come over, that she became hysterical, that she became erratic, that she had mental health issues, and that she did something to herself that night. That maybe she attacked David, that maybe he engaged in self-defense. Did she attack him? Did she threaten him? Will he take the stand and argue that? Was it a heat of passion killing, right? Is this manslaughter? Heat of the moment, not a premeditated murder. Is there an area for reasonable doubt? Because we don't have more information right now about what exactly happened in that 20-minute window, allegedly behind closed doors between Celeste and David, when she allegedly arrived at the home and when David is accused of sending an alibi text, right? They say 20 minutes or so after she arrives, he sends an alibi text asking where she was. There's a gap here. There's potential room. And I got to call something.
Defense attorney Blair Burke also raised a specific legal argument that anticipated future music earnings do not constitute a concrete financial interest under California law for the financial gain special circumstance. That argument has not yet been resolved. The judge found sufficient evidence to hold the case for trial at this stage, but the standard at a preliminary hearing is meaningfully lower than what a jury must conclude beyond a reasonable doubt.
Maybe. I just go back to what attorney Bednarski, defense attorney, said to the court at the prelim. After days of testimony, the evidence only shows a young woman's body was transported and concealed. And while this circumstantial evidence supports concealment of a death, it doesn't support a killing or the requisite intent, forethought that would make it first-degree murder, that the law recognizes two forms of malice. And her argument was neither. And then if you don't have either, there's no murder. Express malice was a deliberate intention to take away a life, and she argued there was no evidence showing deliberate intention here from David. She argued there's no statement of intent anywhere to harm her. There was no history of violence or hostility from him to her. How the relationship, the evidence listed here, is the opposite of homicidal malice. She also argued there was no implied malice. There was no considerable provocation. And she says, counter that, if you look at provocation, it was from Celeste to David, that she was the threatening one. She argued that the 3 special circumstances allegations that would make this first-degree murder charge eligible for the death penalty are unconstitutionally vague. How lying in wait, you look at the text messages that were presented, would arguably show Celeste called for the meeting during which prosecutors claimed she was killed. There was no surprise attack because she knew and expected David.
It is worth being precise about that distinction. Many media reports treated the judge's ruling as validation of the full prosecution theory. It was not. It was a threshold determination. Here is what the prosecution has that is genuinely strong, and this matters for a complete picture. Forensic testimony established that apparent blood stains in the garage of the residence were consistent with a DNA match for Celeste. Blue plastic fragments found among Celeste's remains are allegedly consistent with an inflatable pool ordered to Burke's address under an alias. Mats from the residence had linear cuts and tested positive for possible blood. Burke's Tesla reportedly had 11 air fresheners inside it, and testing found possible traces of blood. That is a substantial body of physical evidence tying Celeste's biological material to spaces connected to Burke. District Attorney Nathan Hochman has publicly stated that what was presented at the preliminary hearing was, in his words, a small but illustrative fraction of the total evidence his office has accumulated. That claim is on the record. So is the fact that no one, as of the preliminary hearing, has been able to say with certainty when Celeste died. Dr. Ho testified he could confirm she had been dead for weeks before her remains were discovered, but could not confirm months. He cannot pinpoint April 23rd as the date of death based solely on the autopsy. If the defense can introduce reasonable doubt about when she died, the entire timeline the prosecution has constructed around that night becomes contestable.
Thing out here too, if you recall, in one of the prosecution's filings, they alleged that David stood by while Celeste bled out. How do they know that? How are they going to prove that? It wasn't like they called an eyewitness who saw that. It wasn't like they had surveillance footage to prove that, at least as of yet. How can they allege that? How can they allege that this was first-degree murder with all these special circumstances? Actually, let me highlight something else from the defense during questioning of the deputy medical examiner, because when you think about the state of decomposition and dismemberment, that's an issue. Dr. Ho testified that he's willing to say she had been dead for weeks because there are weeks and months, but he couldn't say that she had been dead for months because there are no months and weeks. I know it's a little technical, but in other words, you have a witness who can't say certainly how long Celeste had been dead before her remains were discovered. So he cannot pinpoint the exact date of her death as April 23rd, 2025, based on the autopsy. And if the defense can convince the jury that she was alive past April 23rd,
there is one figure in this case who has received almost no substantive coverage, despite being named in prosecution filings. Neo Langston, described as a friend and associate of Burke's, was reportedly arrested for failure to appear as a witness and brought back to Los Angeles to testify before a grand jury. No testimony from Langston appeared at the preliminary hearing. The prosecution also reportedly sought to subpoena members of Burke's family. None of that was presented at this stage. What Langston may have told a grand jury, what family members may have been asked, what associates in Burke's circle may know about the smell reportedly acknowledged on a July 4th live stream, none of that is part of the public record yet. But it may be part of what Hochman means when he describes a small fraction of evidence. That thread remains open, and it may be the one that reshapes what we think we know about how much of this case was observed by people who were simply not placed on the preliminary hearing witness list.
Prosecution's filing, prosecutors alleged that David lied to friends and associates about the alleged smell of decomposition at his home, at his residence. But I don't recall anyone testifying to that. We didn't see Asia Collins. We didn't see Neo Langston testify, purported friends, associates of David. I mean, you go back on July 4th, 2025, according to TMZ, there was a live stream that apparently showed David telling his friends, Neo Langston and Usgana, about this smell in his house, saying he apologized for how his bathroom smells, claimed that he went to the bathroom 2 hours earlier. Is that going to be presented by the prosecution to say he's lying about what the smell was? So a gap for me is, what would they testify to? If you recall, Neo was reportedly arrested for failure to appear as a witness and was seemingly brought back to LA to testify before a grand jury. We know there was an effort to subpoena David's family members too to testify. None of that happened at this preliminary hearing. Gaps. What would they testify to? Would they testify about the purported illegal sexual relationship between David and Celeste? Would they testify about the Tesla? I don't know. But again, the prosecution is under no obligation to present everything they have at a prelim. Remember, Hochman said a small fraction of evidence. And when you think about what those in his orbit, David's orbit, could testify to, one of the potential deficits in this case is that I don't recall any testimony yet that David texted or communicated with anyone about an intent to kill Celeste, or that he was afraid of her, or that he wanted to keep her quiet, or that he admitted to anything. Is that going to come out?
The arraignment for David Anthony Burke is scheduled for August 31st, 2025. That will be the formal reading of charges and the beginning of the next phase of these proceedings. What happens between now and trial? What additional evidence surfaces, whether the missing chainsaw is ever located, whether key witnesses offer new testimony? That is where this case will actually be decided. What the preliminary hearing record shows is a prosecution with serious physical evidence and significant inferential gaps, and a defense with real legal questions to raise and no murder weapon to answer. The evidence, as it stands in the public record, does not add up to a simple story in either direction. Share your read on the 20-minute window in the comments. What do you think the documented record actually supports? And follow for the next deep dive, because the witness testimony that has not been heard yet may change everything.
Forward for trial for now, but I'm highlighting what could be issues at a trial. Look, the next thing that we have to look out for is David's arraignment on August 31st. That's going to be the formal reading of the charges. We'll get a sense of the next steps in this case. Although, let me just call out one more thing. I asked Nathan Hochman on my News Nation show, Jesse Weber Live, about a plea deal here. Now, I didn't mention, would you consider a deal because of gaps in the case? No, because he feels very confident in the evidence. He knows more about it than I do. He feels very confident that they can find David guilty beyond a reasonable doubt. No, I asked him, if you think about what was just presented at this prelim, the graphic photos of Celeste's dismembered body, the allegedly sexually explicit photos of Celeste, do you want to spare a jury from all that? Do you want to spare the family from all that? He hasn't mentioned the death penalty yet, right? Whether or not they're going to go forward. Are they pursuing it? Is it a bargaining chip? In other words, DA, would you possibly consider a plea deal, or do you want to take this to trial?